Our next speaker is from the UK, so it's not going to be any big surprise that he will be mentioning Brexit. He will be talking also about Trump and international data transfers. So I guess it's going to be my favourite topic all over again, which is Privacy Shield and, of course, adequacy decisions. So please welcome Peter Wright, who is the founder of Digital Law UK. Thanks. I'm going to stay here.
Oh, thank you. That's
Coffee. So hopefully, they always say never stand between a crowd and its appetite. I'm just standing between a crowd and its thirst. So you've got me for about 20 minutes just to look at international data transfers. I am very grateful to Finn, wherever he is in the audience, because he illustrated this point brilliantly earlier on when we had the map, the animated map showing data flowing from apps in Europe across to America, showing the fact they were being stored on multiple, personal data was being stored on multiple servers, and it illustrates some of the things I'm going to discuss now. Just to start off, I'm going to have all these slides are available online for those who really want them. So please feel free to drop me an email. You'll be able to see what's on there. You can also get in touch with me online. That's the details. So I'm going to look at the Privacy Shield. Helpfully, when I was asked to put this together, there was an annual review published by the European Commission last week. So that gives me plenty of information to update you on, which hopefully you may not have heard of before. I'm then going to be talking about the UK's departure from the EU. I don't know if anyone's heard of that at all. Yeah, I don't know how much. I mean, obviously, we have the news in the UK, but I don't know how much people around Europe are, if they're getting as much blanket coverage of this as we are. But I'm going to look at it specifically with the point of view of data protection and what's happening there. And then I thought I'd look a little bit at China as well. Now, I was very conscious earlier on that we had the sort of show of hands, and it turned out that about 3/4 of the room are lawyers. So I'm sort of thinking, am I actually telling you stuff that you already know? So, I mean, it sounds like everyone's heard of Brexit before. Yeah? Everyone's heard of that? How many people have heard of the Privacy Shield? Yes, of course. So what can I possibly add to that? And who's heard of China's cybersecurity law? A few hands. Okay, so hopefully this will be a little bit new, hopefully. So, let's kick off. First of all, what is the Privacy Shield? It was the successor to the safe harbor arrangement that was basically demolished by the Schrems decision in 2015. Mr. Schrems ended up making a request of Facebook for all of the information they were holding about him, thinking it would just be a standard amount of information that would come back. And it turned out it was the equivalent amount of information that could have filled a flatbed truck if you'd actually pressed print on the whole lot. So we're looking at a huge amount of data that had been acquired by Facebook over time. We're talking about things where it hadn't necessarily been acquired with an awful lot of the user's consent or knowledge. And that's the way that Facebook works. How do you keep a platform like that free? Well, of course, you're acquiring vast amounts of information, and then you're doing things with it, variously manipulating the data, the analytic data, not just, for example, what someone may like or dislike on a profile, but we're also talking about places they've go, photographs they've been tagged in, locations where they may have checked in, even down to where they've actually clicked on their Facebook homepage. Where do they end up looking when they're undertaking activity on there? So a huge amount of data is being mined every time you go onto a platform like Facebook. And as a result, Safe Harbor was found to be no longer fit for purpose. Not really surprising when we think about it. Something that had been set up really in the 1990s, like our old EU Data Protection Directive. When you think of it, I mean, Mark Zuckerberg was 11 years old in 1995 when our directive came out. So it kind of shows how much the world has changed since then. We are acquiring and storing and processing far much more data than was ever envisaged when some of these older frameworks were being designed and put together. No one could conceive of the sorts of things that we do. No one could have conceived of all of the tweets that have been sent from in this room today. And it kind of shows how much our technology continues to move on at such a fast pace. Which then brings us to the big question, will the Privacy Shield end up actually doing what it needs to? Is it even working as it is? And that's a very, very good question. One of the big problems with Safe Harbor was the fact that organizations could A, self-certify, and then B, half the time weren't even aware they were supposed to be recertifying every 12 months. So you'd go along to a site, they'd say, yes, we've signed up to the Safe Harbor, and then you check, and when did you do that? 7 years ago. Great, so that has nothing to do with what you're doing now then, because people simply weren't taking the trouble to recertify as they should have done. So the Privacy Shield tried to correct things like that. there were far stricter obligations with regards to things like data retention. The idea of all of this data being kept for prolonged periods. Obviously, this is almost echoing a few of the requirements of GDPR, though interestingly, really, it echoes existing European data protection law as well. The whole point is data shouldn't be kept ad infinitum, indefinitely, as seems to be the case by an awful lot of organisations. So it tries to focus on that. It tries to ask for accountability from organisations when it comes to onward transfer. So, for example, when we saw that flow from the dating app earlier on going into the US, what about onward transfer from there as well? Making organisations have an element of accountability with regards to where that data could end up going. There will be things like monitoring. The Department of Commerce undertook to actually take a greater level of control with regards to making sure that organisations were meeting the standards required under the Privacy Shield, and to take more of a hands-on approach than had previously been the case. Redress was also an issue, but the biggest issue probably was the installation of an ombudsperson. Now, this is something that we're really used to. Within Europe, we're used to the idea of having an ombudsperson in place that you can make a complaint to and will deal with the issue and will supervise any complaints. That's a totally alien concept in the United States. And really, it was a massive concession, really, by the US administration at the time to actually account for that and say, yes, we will have an ombudsperson put in. So that kind of shows us a little bit about the safe harbour as it was set up. But then, of course, with the Privacy Shield as it was set up. But then we have the annual review from last week. And this was quite interesting. It's a very short document. If you were thinking, this is one of these EU documents that comes to like 45 pages. No, this one's actually quite concise and quite helpful, and this is it. So it gives us the information from the Commission. They basically went through quite a major data gathering exercise. They consulted with, it's not just the Commission, they've also sat down with the Department of Commerce and various people in the US as well. They've brought in the national heads of regulators in the EU as well. It's been a fairly detailed exercise. And as a result of all this, they've been able to certify the Privacy Shield. And guess what they actually certified it as? Adequate. After all that, it's adequate. Imagine that if that was on a film poster. Blade Runner 2049, adequate, 2 stars. So at first I thought, okay, it's adequate, but actually you think about it, for all the information that's being handled by the Privacy Shield, the vast amount of information flowing to and across the Atlantic, and all we can say is that after a year of operation of this thing, it's adequate. And I found that really, really significant as a result. And then, to try and improve that level, the Commission makes various recommendations. So one of the main things they do is say that, for example, organisations shouldn't be able to say, we are a member of the Privacy Shield, when they haven't actually got Privacy Shield certification. I'll be honest, I'm very surprised by that. That suggests it is a problem. If you've mentioned it in this report, having consulted with all of these stakeholders, this is clearly an issue of people saying, yes, we've passed through the eye of a needle and we have made sure that we comply with the requirements of the Privacy Shield, when clearly it's either pending or they haven't even applied. So, if anything, there is a push here to try and say, we need to stop this activity. And let's face it, this is actually an extension of the problem that we had with Safe Harbour, whereby there was the issue of organisations that either accredited and then didn't bother for a few years, or perhaps even didn't bother full stop to actually do what they should have done. So it's going to the heart, really, of what we require organisations to do. I should add, for those who want to check on this, it's quite an interesting exercise when my law firm, when we're advising businesses where there is an issue of data either going to third parties in the US or going to third-party vendors and suppliers, it's quite interesting to search the Privacy Shield. You can go there, there's a full register, you can search it, and you can find the details of that company, when it was last certified, what they did, what they say they've done. There's quite a bit of useful information in there. There's about 2,500 organisations registered under it so far, but clearly there are an awful lot pending if this issue is anything to go by. But it kind of shows that there has been some buy-in. But then you stop and think, an economy of the size of the US, and only 2,500 organisations have actually registered. Is that a sign of organisations in the US not necessarily being aware of the need to do this? Is it a sign of individuals and organisations in the EU not pushing this as much? Awareness themselves within the EU? Are we actually asking organisations in the US? Well, we presume you have registered for this, haven't you? So it's an interesting sort of knowledge gap. I tend to forget that, the sort of people in this room, we live and breathe this stuff all the time. But then you go out into the wider business community and you start talking about things like GDPR and Privacy Shield and various things, and sometimes I look at you as though you've got two heads. And that's the kind of thing that we've got to consequently bear in mind, that we have to fight against that. And it's part of our role, really, to be almost educators of these mechanisms and rights that many people are blissfully unaware of. Or when you do tell them, they then say, so what? So it's always an issue that, if anything, that's for everyone in this room to sort of think about there when we're trying to make sure that the level of awareness increases. Ongoing monitoring of compliance by the DOC. So here, this is quite interesting. The Commission here is saying quite explicitly to the Department of Commerce, can you please start looking at compliance? This is basically, please put some more resources into it, please take it more seriously, please make sure that we don't have these problems with compliance that have clearly been highlighted. And also talks about raising that awareness, actually making sure that organisations and individuals are aware of the Privacy Shield in the first place. Going on from there. It's interesting, obviously, we're looking at innovation today, and one of the things that the report looks at is having a study on automated decision-making to allow possibly for an element of AI, machine learning to be involved with regards to when it comes to looking at data flows in organizations, particularly in vast organizations with multiple server farms in multiple different states potentially, then being able to have an element of automated decision making and management of this process will of course be a major help to organizations. It may mean that they've got a better incentive to go ahead and do this if it isn't seen as quite as onerous an exercise as perhaps it is now. Interestingly, we talked a little bit about the Pfizer and the protections in there with regards to the Presidential Policy Directive, with regards to non-US persons and the data there. So they're talking about having the protections of PPD 28 in the Foreign Intelligence Surveillance Act enshrined, and there's a little bit of pressure here again from the Commission trying to say we really do want to make sure these protections continue and are clearly present and writ large in US law. And then this is an interesting one. Does anyone remember just after the, in fact, no, it wasn't the inauguration, it was just after President Trump was elected, and he had that meeting with Barack Obama, the first one in the White House. And he'd literally, apparently, before that meeting, been walking through the White House and shaking hands with people saying, oh, really looking forward to working with you in the new administration. And they went, no, it's not how it works here. You know, a presidential administration appoints thousands of individuals, tens of thousands, into the government. It's not like, for example, in the UK, we have a civil service with people that stay there for decades, which means that people can vote whatever they want to do, and very often nothing happens because the same people are actually running the administration. Controversial, okay. But this highlights the problem here. We currently have an acting ombudsperson in place in the US. Now, the whole point of this is that you would have an ombudsperson in place that can issue decisions, that could look at how the matter, how it was being enforced, could look at the pattern of the flow of data, can issue advice to organizations. You can only do that, really, if you have got an indefinite appointment, if you've been appointed for a number of years and can really bed in and have a strategic direction for the appointment. Yet, a year in, we currently still have an acting ombudsperson in place. So again, the Commission is saying, if you could you possibly get a full-time ombudsperson in place? Because it's kind of one of the main planks of the Shield, and currently it's still acting. So again, really significant that this has been highlighted. And then a final bit here, more timely and comprehensive reporting of relevant developments by US authorities. Now, there was a bit of interesting news earlier this year when one of President Trump's executive orders that he had signed, remember there was that flurry of them earlier on in the year, where I think he wanted the record of having signed the most very early on in his administration. Well, having done that, one of them affected the US Privacy Act of 1974. And it turned around and sort of taking one of the sort of campaign pledges of America First, it basically said the data of US citizens is sacrosanct, but in terms of the data of anyone else, that's going to be fair game for the US security services to look at in terms of making sure that we are keeping people safe. So it sort of put that in place, and immediately there was then sort of major alarm bells ringing in Brussels, because of course that's going against one of the central tenets of the Privacy Shield, the idea being that data of EU citizens being stored in the US isn't being looked at on a free and available basis by US security services. Now, at the time there was a little bit of a concern, and the Privacy Shield had only been running in January of this year for about 6 months. And there was a lot of people saying it might not even make it to 12 months at this rate. Well, clearly it has. It clearly has. But there are stresses and pressures against it. It's got the gradual nibbling of it taking place in the US there, the fact that we only have a temporary ombudsperson in place, the fact that we have people who are rushing around saying that they're certified when they're not, is a major problem and a major weakness for it. Then in the EU, we still have potentially Max Schrems coming back and taking the regime of the Privacy Shield to court as well, and that will probably happen in the not too distant future. So there are stresses and pressures on the Privacy Shield all the time. Does it have a long-term future? Probably not, if we think about it. It's amazing, really, that the safe harbour lasted for the best part of 15 years. Having that system in place when it was clearly under pressure from the rapidly changing nature of globalization and how data is being stored and transferred. The chances of the Privacy Shield ever lasting anything like that, 15 years, were always going to be remote. It's interesting to consider, is really the Privacy Shield, which was a concoction of the European Commission and President Obama's White House, was it really just a sticking plaster on a much bigger problem in terms of the storage, use, transmission and destruction of data in the US? Is it something that perhaps the comprehensive trade deal that was to be agreed, the Transatlantic Trade Investment Partnership, which pretty much died upon President Trump taking office when he said, I don't agree with these multi-party trade deals, would that actually have put the issue of data sharing on a firmer footing? Well, due to an awful lot of the privacy restrictions around that document, we can't be sure exactly what was in there. But surely if you were going to unify trade and set up a massive free trade zone over the North Atlantic, you would have actually had some real solid provisions in place to allow for the free exchange of personal data, making sure there were adequate controls and safeguards in there. So the Privacy Shield has made it 1 year. We should have a little cake with a candle on it. It made it that far. Will it make another year? I'd like to think so, but who knows? Really, who knows? It could it could end up all come crashing down sooner rather than later. It's currently interesting to go and search the register. I'd urge you all to do it before it ends up being taken down. But it's an interesting exercise to do. It tries to go a long way to fitting in with what we want in Europe, but it may not end up lasting the course, which may be a shame. So here we go. UK departure from the European Union. So as you can see, I've got this map of the world here, and I thought, how do I accurately show this and portray it on the map? So I thought the best way of doing it was that. Because obviously we aren't actually lifting the anchor and going into the Atlantic, though to listen to certain politicians in the UK, that's exactly what seems to be happening. But it's interesting then when we look at the issue of the flow of data. 3/4 of the UK's flow of data outside of its borders, 3/4 of that goes to the remaining EU 27 states. And let's face it, closest market, that is of course perfectly obvious that would be the case. So the decision was taken, let's incorporate GDPR into UK law. This was a bit of a shock for rather a large number of businesses who the day after the referendum in 2016 went, hey, we don't have to worry now, we're leaving Europe, ha-ha! And then literally a large number of organisations pulled the plug on their preparations, going, well, that's it, that's not going to come in. The first thing that my firm did was we put on our website, more than likely this is going to come in, because they'd already made it clear that certainly the UK wasn't going to leave the EU within the next year. That wasn't going to happen. Indeed, it took the best part of a year just to trigger Article 50. So certainly that was never going to happen. The UK would still have been a member of the EU come 25th of May of next year, regardless. So it was still going to become law in the UK. And then it became quite clear that the decision was being taken to incorporate all of the existing EU law into UK law. via something originally called the Great Repeal Bill, and has now got the slightly longer-winded title of the Leaving of the European Union Withdrawal Bill 2018. I say 2018, it might not make its way through Parliament by that time if the 300-odd amendments that have been tabled so far end up being taken into account. But the whole idea was they actually said, right, because of the issues with that large piece of legislation being passed to withdraw the UK from the EU, they're actually having specific acts brought in with regards to certain crucial areas of the economy, and data protection was felt to be one of them. So there is a new Data Protection Act that is coming in. The majority of people in the UK are blissfully unaware of this. There was one rash of media coverage in August about it, which covered total misinformation, avoiding actually saying this incorporates GDPR into UK law. It talked about other issues instead. So I thought if you're talking about helping the majority of business owners know about this, unfortunately it's not been done particularly well. But there will be a new Data Protection Act. Our current Data Protection Act dates from 1998 that incorporated the original EU directive into UK law. So exactly 20 years later we'll end up with a new Data Protection Act 2018. More than likely. It incorporates GDPR in, it goes through the derogations, it decides exactly how it wishes to put them in. There's also a fairly large tract with regards to enforcement, because of course we'd be enforcing it from outside of the jurisdiction of the EU, so there are powers in there for our UK Information Commissioner, Elizabeth Denham. Elizabeth Denham has now been in position for a couple of years. Very interesting. I've heard her speak on several panels, and she is taking a much more proactive approach with regards to data protection regulation than her predecessor, a gentleman called Christopher Graham. The death knell for him was pretty much when there was an inquiry taking place into press hacking of people's mobile phones so that they could generate different stories and things. And it became apparent that the government was talking about, well, shall we regulate the press and shall we have new laws? And as is always the way with the government, wanting to find something to do to show it was being busy. And when Christopher Graham was being cross-examined as part of the inquiry, it became quite apparent that there were more than sufficient existing laws. He just wasn't enforcing them. So there has been significantly more enforcement carried out by Elizabeth Denham with regards to the security and privacy of these sorts of records. It's interesting looking at what may happen in the future. So this act is coming in 2018. But interestingly, the ICO is already looking at a few other areas of concern. One that has been identified is, for example, the fact that GDPR encourages things like, well, we have a slightly enriched version of the definition of personal data. But under GDPR, once that is anonymized, if you've taken out or pseudonymized the personal identifying information, GDPR in effect almost falls away in certain instances. So it asks the question, what should we do with data after it has been carefully anonymized or pseudonymized? What should we actually be doing with it? Is it then open season for any corporation to keep it for as long as it wants, send it anywhere around the world that it sees fit, manipulate it in any way it wants, or should we still have some laws that apply to it? And this is an interesting area of work that the ICO is looking at. They've obviously also identified the fact that GDPR, its main focus, as all existing data protection law in Europe has been, the main focus has always been on personal data. But they're also saying, well, what about confidential information? What about things like trade secrets? What about commercial confidential information? Should we actually start looking at having wider regulation and protection for that as well? So it'll be interesting to see if there ends up being a little bit of a divergence there, perhaps, with regards to the future regime in the UK, where they start focusing on different types of data as a result. So it'll be interesting to see exactly where that goes. Interestingly, I was at an event last week in London, and they were saying about the fact that the different approach in terms of regulation in the EU compared to the US. And they said, you know, let's face it, in the US, if it isn't expressly prohibited, it's pretty much allowed, whatever it may be. In the EU, it's the other way around. Unless it is explicitly drafted and permitted, it's not allowed. Seems to be the general sort of starting point that they were taking. So it'll be interesting to see where exactly the UK decides eventually to bring itself to rest with regards to this. So, final quick bit, I thought we'd look at China. I can look at international data flows in the UK and the US, but there is a wide world out there. And China passed quite a significant cybersecurity law on the 1st of June 2017. It introduces a few things which are quite radical, certainly radical in terms of what was previously in China. Interestingly, this law comes from a working group that was actually established and pushed forward by President Xi. So clearly they're taking this very, very seriously. They've introduced fines, for example, of up to a million yuan for transgressions of the cybersecurity law. That's about €130,000, approximately, on today's exchange rate. But it kind of shows the seriousness. I mean, okay, €128,000 isn't major compared to what we've been used to in Europe before, but it's still a major shift and change in the culture. So a few interesting bits of information that I thought might be interesting to look at. I've just tried to distill this down into the 5 main points. So we have things like personal information protection, trying to define and protect personal data. We are, of course, very, very used to that. There are greater security requirements for network operators. Indeed, they are supposed to actually have got a level of certification in place themselves before offering their services to customers and organizations out there. So again, a fairly major shift. Interestingly, of course, this is generating work for a regulator in China, but it's obviously a very different approach that they have to regulation of this compared to the EU and the US, as we've been looking at earlier. They're protecting things like critical information infrastructure and critical national infrastructure, for that matter. Of course, no one wants to particularly have their nuclear power station hacked or any other item of major infrastructure, so they're wanting to make sure there are protections and securities in there for that as well. There are restrictions on the transfer of personal information and business data overseas as well, so looking at the issues that we're trying to already take account of within GDPR and the Privacy Shield, and the aforementioned penalties as well. So that's a quick run through of the Chinese situation there. So I am, again, acutely aware that I'm standing between you and coffee. Please do feel free to get in touch with me at Digital Law UK on Twitter. I'm also on Facebook, facebook.com/Digital Law UK. If you want to see the occasional interesting news story that we put onto our page, then please do feel free to give us a like on Facebook. If you'd like these slides, please drop me an email, peter.wright@digitallawuk.com. We've also got a website, that's the name suggests. And also, I should also give a quick plug here. I occasionally do a podcast with Frederick. Frederick Savard, who's the Secretary General organising this event today. So if you want to hear two guys really geeking out on the finer legal issues around this, then please do feel free to listen. Do we have any listeners in the audience? I was hoping there might be one or two. Yes! Whoa! Hello, I'll buy you a drink later on. Fantastic. I was wondering if we had any or not, but that's really good to know. Fantastic, great. Thank you all very much for listening. Please do feel free to get in touch, and I hope you enjoy the rest of the conference. Thank you.
And we don't really have a lot of time because it is coffee time for follow-up questions. I will ask one question based on the Privacy Shield that you didn't mention, is that there's not been one single complaint yet under Privacy Shield. Are you surprised?
Well, that almost fits into the fact that are people aware they can complain?
Okay. Well, yes,
Really?
but still, according to the Commission, it's working well.
Yes.
Working well by doing nothing. So that's
Yes.
great. Enjoy your coffee, and we'll
Adequate.
see you back here.